Hello guys, can you hear me?
I can hear you. Good evening.
Yes, good
Yes, I
evening.
can hear you, sir. Good evening.
All right, thank you. Good evening. We are starting right about now. Welcome to class. Um, yeah, I can see we are only two, and for I think for the last 2 or 3 weeks, if I'm not mistaken, it's just you guys that have been consistent in the session. I really want to appreciate the efforts and you guys showing up every time. All right, so well done to both of you. I really do hope that we have more of your comments show up in today's class. So but not to waste any time, we'll soon have our mentor join in. Welcome to the JT Mentorship and Internship Program Week 5. And in today's class, we'll be discussing filing patent application. All right, and this week we will not be having Mrs. OGS, Mr. Rakesh Sharma. Um, I'm sure he'll be joining us soon. He sent us a message that he would be joining in shortly. Sorry if there is any noise in my background. Rakesh is having is just having he's having a thorough and multifaceted career spanning nearly a decade in patent analytics, drafting and prosecution for US and EP jurisdictions. He worked very closely with various engineering teams and supported their portfolios from idea incubation to innovation management. Mr. Rakesh has excellent understanding of patent law, claims interpretation, and drafting skills. As a seasoned professional, he is readily engaged with various end-to-end IP services at different levels and providing intelligent IP solutions. He emphasizes more on promoting innovations for a better world, the laws drafting patent claims, keeping all the infringement perspective in mind. Furthermore, he has a strong bent of mind towards IP automation and has a sound knowledge on various IP tools and techniques that can be used for either improving quality of IP or increasing the overall productivity. He is also an excellent mentor and possesses all the leadership qualities required for a successful IP career. So Mr. Rakesh is going to be our mentor for this week. I'll just kindly ask that we give him a few minutes to join in. But before we move over to that, I just have a few questions for us. I just have a few questions for us. Sorry, let me stop sharing my slides. Okay, I'm turning on my video. All right, so I want to ask firstly, um, considering that I messaged the group presenter and I wasn't able to get through to her. So I was just wondering to ask how we are going to go around with presentation today. Is any of you going to be filling in for her?
Okay, I had spoken with the group presenter this morning, and she let me know that she would not be available for the section. I also spoke to the backup presenter, and she also relayed that she would not be available for today's section. So I would have to take the presentation myself.
All right. So sorry, we had to deal with the situation like this. All right. Otherwise, we ought to have the people who were assigned their tasks or their roles attend to it. But irrespective, it is good that you are stepping up to take it. Obviously, it just shows your commitment to the session. So thank you so much, Chenny, and thank you also, Favor, for all your commitments to class. All right, okay, we have Mr. Rakesh on the call. Thank you so much, Mr. Rakesh, for joining. We are happy to have you in today's session. You're very, very, very much welcome. Mr. Rakesh has been one of our very consistent mentors over the last couple of years, and he has been very passionate about patent drafting. And I'm sure that in the short time that would be, or in the time that we'll be having him for class today, he will be doing due justice to the topic for today. Like I mentioned, the topic for today is filing patent application. So Mr. Rakesh, thank you once again for joining. We are so happy to have you with us on the call. So we will be taking Mentee's presentation a little bit later, but we wanted to find out if you had something prepared for us for class today. Sorry about the noise in my background. Subsequently goes on, then when Mr. Rakesh is more set, we will be getting to hear from him. But let's take presentations from you guys first. So please, Chenny, thank you once again for volunteering to take the presentation in class. You can go ahead and start presentation. If you need assistance with sharing your slides, you can just let me know.
I would want you to share the slides for us.
So give me a minute. Let me quickly get them up. Can you see my screen?
Yes, I can. Good evening, everyone. Today's topic is optimizing patent application strategies, a comprehensive analysis of filing processes, durations, priority considerations in provisional, local, regional, and international contexts. Please, can you go to the next slide? Please, can you go to the next slide?
Okay, I'm on the introduction.
Okay, so when invest in inventors, when they invent a product or a method for doing something, their main aim is to get patent protection, which would enable them get back the investment or the money they have put into their investment in their invention. So we have come to realize that patent protection is territorial. That means if you would want protection in a lot of countries, you would have to file in those countries. So because of that, because inventors know that if they invent something, it may not only be in one location that they would want to showcase that invention and they would want to invest or they want to, showcase it or protect it in other countries. This is the reason why international patent filings are very important. So we are going to be looking into the different strategies if an inventor would want to protect his invention through patent. Please, can I see the next slide? All right, so starting with the provisional patent filing process. This is basically making an application to the patent office with sufficient details of that invention just to secure a priority date. This is usually done when you would want to, um, let's say, disclose to an sorry, when you want to disclose this to someone who wants to invest into the idea of your invention. So the fact that you can disclose this to an investor and there's a possibility that they can register that um, invention before you. To avoid that risk, you just file a provisional patent application just to secure the priority date and just to keep the status of that patent pending until you file or convert it to a non-provisional patent application. So with this, once you file your provisional patent application, it is only valid for 12 months. If you miss the deadline, it forms part of prior art and you'll be unable to register it fully as a patent. For the draft of the provisional patent filing, these are the details you would need to disclose to the patent office in order for them to sort of keep the status of your patent application as pending. So, when you file a provisional patent application, one thing is that you don't need to file the claim, but you must give sufficient details as to that invention. Can I can you go to the next slide? All right, let's talk about the local patent application filing process. And we are using Nigeria as a case study. So what happens in Nigeria is that firstly, you have to run a patent search. And because a lot of patent applications details are not digitalized right now, you would have to physically go to the patent registry to conduct a search. Afterwards, you prepare your patent documents and you file that at the registry. You pay the prescribed fee, and then the patent registry will undergo an examination of that patent application, and they would either grant it or reject it depending on if your patent application discloses the patent legal requirements. Can you go to the next page? All right, we have for the regional patent application filing, we have the European patent system. This is usually administered by the European Patent Office. So basically, there is a convention in which the European countries are signatories to, which means that if you file a single application with the European Patent Office, they conduct a search and examine that patent application. They can decide to either reject it or grant that patent application. So if it is granted, then that patent is validated in the state, like the member state of the treaty in which you have selected that you want your patent to be protected in. The next slide, sir. Now we have the African regional system, and they are two in number. Firstly, we have the African Regional Intellectual Property Organization. This is for um, countries within the African continent. This is for mostly the Anglophone countries. So firstly, you file an application to the patent sorry, you file an application through the African Regional Intellectual Property Organization, and then if that patent application is examined and is granted, then that patent can that application can be either rejected by a member state or accepted. So in this situation, you cannot just file one application through the outpost and then every member state that is a signatory to this would accept it, because most of the times when you file an application, even though at the time when you file the application, um, there might not be persons in their own states who have similar patterns, but if you do and they discover that either your application does not cover the legal requirements for their own country, they might decide to reject your application. So the second is that we have the organization Africaine de la Pro- Propriété Intellectuelle. This is for Franco. This is for francophone countries, and unlike the African Regional Intellectual Property Organization, once an application is granted to a person of a member state, then state, every other member state cannot opt out. So they will have to accept your patent application in their own state, and you gain patent protection in other member states. The next slide. All right. So we will talk about the international patent application filing process. This is mostly through the Patent Cooperation Treaty, and there are over 157 contracting states under the Patent Cooperation Treaty. What this does, or the process of the patent application, is that firstly you may file through the your regional or national office or through the receiving offices. So when you file an application through the receiving office, they send it to the WIPO International Bureau. The WIPO International Bureau would make a search and give you opinions, a written opinion as to whether that patent application can go through or not. Then when they grant the patent application, they will publicize the patent in the patent scope, so that we can all know that okay, this patent is now registered. And before then, the inventor would have to select the state in which he would want to be protected. So after that patent application has been accepted or granted by the WIPO um, International Bureau, then the inventor has within 30 days to go into the individual countries in which he has selected during his application to file patent application. The next slide. All right, these are the strategies that an inventor must have in order to fully protect his patent rights. Now, before choosing a strategy, the inventor will have to consider the commercial market. All right, what location will be best for his product? Where are his competitors located? He will also have to consider the nature of the invention, whether it's a long-term product like pharmaceutical product, or whether it's a short-term product or like fast-paced product, which is like tech. and he would also consider the cost constraints. So if he decides to register individually in each of the countries in which he seeks um, protection, it might cost him a lot because you will need to get attorneys in each of those countries, pay attorney fees, pay filing fees, and all of that. So he will need to consider how much he's willing to spend before he chooses a proper strategy. And then the time sensitivity. If you file an application in a particular country, you have you have a certain deadline before you can equally file in other countries. All right. For the strategy, we have the foundational strategy. This is mostly filing in your own country, filing through your national office. The regional filing strategy is going through either the European filing system or the African filing system, as we had explained before. You can also go through the patent cooperation treaty route, which is basically filing an international patent application, which basically enlarges your time to file in other countries. Then for the provisional filing strategy, this is usually done if you just want to secure a priority date in such a way that you're not the delay or disclosure of your patent application does not make you lose your right to actually patent it. So immediately you file a provisional application, you can claim the priority date of that provisional application to complete your application, and your right is not extinguished. And lastly, we have the national filing strategy. This is basically going to different countries and filing individual applications in those countries, which is more expensive than every other strategy that we've mentioned. So, bearing in mind the commercial market, nature of invention, cost constraint, and the time sensitivity, the inventor can decide to go through any of these strategies in order to protect his patent. Please, the next slide. Then the duration for a patent application. Basically, patent protection is granted for a limited period of 20 years from the date of filing of that application. Next slide. The priority date and period. The priority date is basically the first date of your first application. So if a person files just one application, then that date is just mainly called the filing date. But if he decides to file subsequent applications for the same invention, then he can claim that first filing date as his priority date. So he is allowed to claim that for his subsequent applications. Why is it important? So that being you're not being told that your application or your patent is part of prior art. All right, so you usually claim your priority date so that when you go ahead with your patent application, the priority date appears on the application to show that this was the first time you had actually gained protection for that patent. When to claim priority date? You claim priority date when you have filed a provisional filing or application. So when you would want to turn, because a provisional application is usually an incomplete patent application, and the main aim is to claim priority date. So at the time when you want to convert it to a non-provisional application or a complete patent application, you can claim that you have started the process at so time at the time when you made your provisional filing. Again, in a situation where you had filed in your own country or in one country and you decide to make an international filing, you can, make your date to relate back to the first date of your application. That's the filing date or the priority date. Next slide. All right, these are the questions that we have for our tutor. In practice, how can an applicant decide between using the PCT route and filing directly in multiple jurisdictions, especially when working with limited resources? And secondly, when dealing with multiple priority claims, what are the most common mistakes applicants make, and how can they ensure that all aspects of their invention are adequately protected? Thank you.
All right, thank you, Jenny, for helping us run through your group's presentation. Well done to you and to your team for putting it together. Mr. Rakesh, sir, can you hear us now? Hello, Mr. Rakesh.
Yes, I am here.
All right, thank you so much, sir, for joining. We are happy to have you with us in the session today. You are very, very, very much welcome, sir. So we have just taken presentations from the mentees, and we wanted to get to hear from you based off of what you prepared for us in today's class. And then maybe any feedback to their presentations, we'll take questions, and that will be that for today, sir.
Okay, so I would like to start with the presentation my fellow colleague was presenting earlier, the Chini. Uh, so this is related to the filing strategies. So I agree with Chini that she mentioned when to file provisional and when we have to adopt international route. So it all depends on one thing. Uh, Related to patents, and it is related to the commercial value your idea has. For example, if your invention is having sufficient value in multiple jurisdictions, based on the due diligence you conducted, like if it is valuable or being enforced in multiple jurisdictions, for example, in China, US, Europe, India, then I would recommend to go for the two different routes. It could be the international patent application or the filing a provisional. So both are having their own pros and cons. Indirectly, what we can provide you is suppose if you are like your invention is still under research and development and there is lot more to explore in terms of different embodiments or application areas, and still it is at its nascent stage, then going through the international route would be helpful because it will give you additional 30 months timeline by securing the priority date. And if you are much more confident that you have invented the best mode and you have developed the core of the invention, still multiple application areas are still we need to explore. In that case, 12 months window of filing a provisional and then non-provisionals or in the foreign jurisdiction would be sufficient. So it all depends on two different criteria. One is the technical merits. The second is the business merits in different jurisdictions. That where and how you can enforce your invention. For example, China is the biggest manufacturing hub. So if your invention can be used in any ways in manufacturing those prototypes or products, your invention could be utilized. So in that way, it is an ideal market for you to file a patent in China. In the same way, for Europe or US, if it is high chances that this technology would be used there with those gadgets which were produced or manufactured by China. So it would be an ideal scenario to file patents in those jurisdictions also, so that you can produce the licensing fee in terms of royalty from all those infringers who might be infringing on your invention. So from those merits perspective, it comes with cost also. For example, if you want to go from the international route, which gives you 30 months timeline, it gives you additional cost also. In the same way, if you want to go with the 12 months timelines of filing a provisional and then within 12 months non-provisional, it will come with a lesser cost as compared to those international route. Any questions so far on this? Anyone? Okay, then I will take it as a no. And continuing to the filing strategies, this is the what we are talking about is the core of all those strategies we are building upon for filing. In addition to all these, the secondary parameters that which we need to consider are those which help in more infringement or more licensing opportunities or more towards the strict IP laws in any jurisdiction. Suppose if you are filing a patent in any country where IP laws are not much strict, but chances of infringement are high, but you cannot prove infringement in those jurisdictions, or it is much difficult or near to negligible or none. So if you are filing a patent there but could not prove infringement and could not get any royalty, so it is a wastage of money, time, and effort. So these are the secondary parameters which we need to consider while we are deciding to file our patents in any of the jurisdictions. So these should be your filing strategies, not only the technical merits, but business relevance as well as the legal relevance, that how strong are the IP laws in any of the jurisdictions where you are heading, so that your invention should get the proper justice if it is getting stolen by any third party. Any questions?
No,
Sorry,
sir,
please, if
no
you can.
question.
Okay, so please, if you have questions, let's ask. But if we don't, we can also respond. Thank you. So no questions, sir.
Okay, no questions. Then I would want to proceed with another aspects of it. While analyzing the invention, while conducting the patentability search, I would always recommend to perform the complete due diligence to understand the technology landscape, so that from all different perspectives we can file a patent. We must ensure that in how many different ways an invention can be exploited. We should have to consider it from that perspective of a having a thief's mindset. Suppose you are building locks, or you are like trying to ensure the safety of your house. So you can only achieve 100% security if you are like developing a thief's mentality, that in how many ways somebody can enter into your house, and then only you can protect your house from all those different scenarios. But if you are considering or keeping your mentality as a nobleman or honest man or a responsible citizen, then you might be missing all those possible routes where somebody can enter and steal your valuable assets. So the same analogy is applicable while you are filing your patent application in any of the jurisdiction, because it is your idea or your client's idea if you are representing your client. And if you are not covering it from all different perspectives, it is equivalent to you are making it not foolproof or theft proof, and anybody else, if getting a chance, they will try to steal their part or their contribution or their side of the invention. So we must have to think from the infringer's perspective when we are evaluating or when we are deciding to file it, and how and in what manner we are filing in which particular jurisdiction. It is not always beneficial. Suppose two examples I can give. One is the example of a bigger portfolio. Suppose there are tech giants, for example, IBM, Google, Amazon, Accenture, Wipro, or any other big tech giants who are having bigger portfolios of more than like 1,000, 2,000, or 5,000 patents. So they are not having any budget crunch, and they are operating across the globe in multiple countries. Either they are manufacturing in one country or they are importing those manufactured product and assembling it and selling it. So it is necessity for those companies to file their patents in multiple jurisdictions. But in contrast, if somebody who is even having only an individual inventor or whoever is having a startup and having a budget constraint along with limited scope of their invention in only one or two jurisdictions. So for those, it won't be advisable to spend extra money and extra time to file it in all jurisdictions where these startups are non-operational. So it might be beneficial always if you are not having any budget crunch, but otherwise it will be, if you are not exploiting your inventions in those jurisdictions, it will be a wastage of time and effort and money. So it all depends on your proper due diligence or your market research, where and why you are filing your patent application. Any questions?
No, sir, no questions. Thank you.
So every time, like, consider, because patents are intellectual assets, or we call it intellectual property, try to like create an analogy of this intellectual property with the physical property. If you are buying a piece of land in any of the jurisdiction and you are not properly creating the boundary walls, any trespassers will be passing through that piece of land, or anybody can do the encroachment also, and you won't be able to stop them. So every time anybody is willing to file in multiple jurisdictions, suppose if you are having money, you won't be buying a piece of land everywhere in every country. You will be doing the due diligence and trying to calculate the gross margins and the profits, that if I would be buying in one particular country, then what are the chances of growth, or the investment perspectives, like how and in what means you will be able to generate money from that piece of land, either by uh, creating your own home, or by constructing a shop or a showroom there, or by constructing a school or college or restaurant or hotel or a hospital. That all depends on the due diligence you are performing. And it is not like a one size fits all policy. It all depends on the jurisdiction and the local requirements your invention is fulfilling. So never ever follow any thumb rule. Whatever is applicable in US might not be applicable in China or Europe. So never ever try to follow a blind thumb rule that okay, if this invention got success in these jurisdictions, all applications will got the same success. It is not true. It all depends on the merits of the application and their practical applicability in that market. Understand the market and understand the infringers, and then your invention will give you the profitability in different markets. Any questions?
No, sir, we perfectly understand.
So, in a nutshell, I am summarizing the intellectual property or patents are the technical documents, but decisions to file it in multiple jurisdictions are not only dependent on the technical merits, but it also require the business understanding also. So business related, wherever it is fulfilling the business relevance, that those questions should also get satisfied in addition to the technical merits. Technical merits will remain almost same in all the jurisdictions because it requires three major parameters, that is novelty, inventive step, and practical application. And more or less, these three are same across the globe with minor changes in the definitions or the local requirements. But one thing that keep on changing and that differentiates like local markets or the one market from the other is the business relevance. So you need to understand that also. And the third point is the how strong are the IP laws in that jurisdiction. Accordingly, you will be able to decide, okay, this market would be profitable if we file our patent here, and we will be able to generate a lot more royalty from our patents. So according to these parameters, you must have to define your own parameters. Be very particular and clear about those parameters, that why and how these will be profitable to the business you are supporting. And if you will be able to get the answers of those parameters and you do the proper due diligence, you will get the answers to file it in any of the jurisdiction. And you will also be able to decode that whether you need another 30 months and why you need to follow the international route, or your invention is ready and you need only 12 months to file it in multiple jurisdictions, and for that you have sufficient amount of budget also. So these parameters, if you keep in your mind and you do the due diligence around these parameters, it will always give you the right perspective in your mind. Okay, we are doing the justice with the ideas of the inventions you are handling, and it will always give you the profitability also. That's all from my side. Feel free to ask any questions if you have. I
All
hope
right,
I
thank
was
you so
able to explain. I hope I was able to explain it to very layman terms.
Yes, you were, sir. Yes, you were. We properly did understand. Thank you so much, sir, for your shared thoughts in class. And I noticed that while you were speaking, you also addressed the questions that were asked. That were asked in the presentation. So thank you so much, Mr. Rakesh, for even though it was, I think, roughly 20 minutes, but in that short period, you were able to run us through directly the procedures for filing a patent, the strategies to use, considering the markets that you'll be filing in, where it will be necessary to file in, and where it won't be necessary to do that. So thank you so much, Mr. Rakesh. If we have any further questions for Mr. Rakesh, please can we go ahead and ask those questions? Are there any other questions you'd like to ask him? Maybe not just in relation to the particular topic for today. If there are other areas or aspects of the patent drafting that you do not understand or you are having a slight difficulty with. Mr. Rakesh is a thorough professional, so you can go ahead and ask him, and I'm sure he would have an answer for you.
Okay, I don't have a question for now, but I wanted to know if Mr. Rakesh could give us his contact information because I have decided that after some classes I would need to start doing drafts of patent applications. So I would need somebody who would look through the draft applications and let me know what I may be, missing out and just give me guidelines as to it. If he does not mind, I would appreciate that.
Sure, I'm always ready to help. Feel free to get my contact information from them and feel free to reach out to me. I'm always ready to help.
Thank you so much, Mr. Rakesh.
All right, thank you very much, sir. Chenny, please, you can kindly reach out to us after the class, and we'll share Mr. Rakesh's contacts with you. All right, so I think we are done, right, technically. Right. Thank you once again, Mr. Rakesh, for making our time to be here. We know that it's currently quite late over there in India, but you still spared your time to be with us in the session. We are very sincerely grateful. Thank you so much, sir. So please, can we kindly just quickly turn on our videos? Let's quickly take our pictures while we draw a curtain to class. Please, let's quickly do that as fast as possible. All right, thank you, Chenny. Okay, thank you, Mr. Rakesh.
Sorry, please. I'm not in a place where I can turn on my camera. So is it okay if I just keep it turned off?
Yes, please, that's fine. All right,
And feel free to
so
reach
yes,
out to me after this call. Chini, you can reach out to me immediately after this call, and I would be happy to assist you. Okay.
all right. So thank you
Thank you
again,
so much,
Mr.
sir.
Rakesh. Thank you again, Mr. Rakesh, and thank you to all the mentees that are here. So for the mentees, kindly note that this is officially our last class. This is officially our last class in the patent session. The other classes or the subsequent classes we'll be having will be more of a combined class with other mentees in the other courses. Well, the explanation will be sent to your group. So please kindly watch out for that while we prepare to enter week 6. So thank you so
All
much
right.
for making our time to be present all the way from week 1 down to week 5. I'm sure that the information you have gotten throughout the course of the program has been helpful. And I hope, it is something that you would take into cognizance to not just allow it to be head knowledge, but something that you can apply practically while you try to fine tune yourself within the patent drafting space. So thank you everyone for being here. Please do enjoy the rest of your evening and bye bye.